This new immigration law marks one of the most important turning points for green card holders in more than a decade. Officially passed by Congress and signed into law, this is not a temporary policy, not an executive memo, and not something that can easily disappear with a change in administration. It is a permanent legal reform that reshapes how lawful permanent residence is monitored, verified, and maintained in the United States. What makes this law especially significant is the bipartisan support it received, which signals long term stability and enforcement. In practical terms, that means green card holders must now adjust to a system that expects ongoing engagement, organization, and compliance rather than passive status maintenance. The stated purpose of this law is modernization. The U.S. immigration system is moving away from paper files, manual reviews, and discretionary decision making, and toward a digital, data driven structure built on biometric verification and interagency data sharing. Security, accuracy, and compliance clarity are at the center of this reform. While daily life for most green card holders may not feel immediately different, behind the scenes, agencies like USCIS, DHS, and Customs and Border Protection are now relying on interconnected digital records to assess whether lawful permanent residents are meeting their responsibilities. For many years, once someone received a green card, the expectation was relatively simple: avoid serious legal trouble, renew the card every 10 years, and live your life. That era is ending. Under this new law, maintaining lawful permanent residence is no longer passive. It now requires active participation. Travel history, employment records, address updates, tax filings, benefit usage, and biometric data are all linked together. Even individuals who have lived in the United States for decades must adapt to this more structured system. Those who remain organized and informed will experience stability and security, while those who rely on outdated assumptions may face delays, scrutiny, or unnecessary risk. One of the most important changes introduced by this law is the requirement for mandatory biometric updates every 5 years. While the green card itself still carries a 10-year validity period, the government will now require updated fingerprints, photographs, and signature verification on a 5-year cycle. USCIS will send official notices requiring green card holders to complete these biometric updates within a strict 90-day window. These updates apply even if the green card itself is not close to expiring. Missing a biometric appointment is no longer a minor issue. It can result in employment verification delays, travel complications, or problems with future immigration applications. The system is automated, meaning non-response is flagged without human discretion. The safest approach is to maintain an active USCIS online account, keep your address updated at all times, and respond immediately to any official notice. International travel rules for green card holders have also become more structured under this law. Trips outside the United States lasting longer than 60 days must now be reported in advance, typically at least 2 weeks before departure. This reporting requirement allows immigration authorities to better assess intent and track extended absences. For trips exceeding 90 days, additional documentation may be required, such as proof of employment, family ties, or ongoing residence in the United States. While failing to report qualifying travel does not automatically cancel a green card, it significantly increases scrutiny at reentry. Customs officers now rely heavily on digital travel histories rather than verbal explanations alone. For green card holders who travel frequently for family, business, or medical reasons, careful planning is now essential. Failure to properly report travel can result in secondary inspection, delayed entry, or questions about abandonment of permanent residence. At ports of entry, enforcement procedures are increasingly data-driven. Officers instantly review travel patterns, lengths of absence, and overall compliance history. Even if each individual trip appears lawful, frequent travel can trigger pattern-based scrutiny. In this environment, explanations without documentation are no longer sufficient. The smoother your personal records align with government databases, the faster and safer your re-entry into the United States will be. Another major area affected by this law is public benefits usage. Data sharing between public benefit agencies and USCIS has been strengthened. Certain benefits now trigger reporting requirements, while others remain fully excluded. This law does not prohibit green card holders from accessing assistance during periods of hardship. However, it does require transparency and accurate documentation. Emergency services and legally protected benefits are excluded from negative consideration, but inconsistencies between benefit usage, income reporting, and immigration filings can raise questions during renewals or citizenship applications. The safest strategy is not avoidance, but documentation. Keeping records that explain why assistance was temporary or necessary protects future eligibility and good moral character assessments. The citizenship process itself has also changed in important ways. While the basic eligibility timeline for naturalization remains the same for most applicants, the review process has expanded significantly. USCIS now examines the entire green card history in greater detail, including taxes, employment consistency, travel records, address history, and compliance with new reporting rules. Citizenship interviews are becoming longer and more documentation focused, with officers cross checking digital records against applicant responses. This does not mean citizenship is harder to obtain, but it does mean preparation is more important than ever. Waiting until the N400 stage to organize records is no longer recommended. Employment verification is now closely tied to the biometric update cycle. Employers may be required to re-verify work authorization every 5 years, even for long-term employees. If biometric records are outdated, employment verification can be delayed, potentially disrupting hiring or job transitions. While green card holders do not lose work authorization due to these delays, staying ahead of biometric compliance protects income stability and career continuity. Under the new system, keeping documentation current is no longer optional. It is part of professional responsibility for lawful permanent residents. One of the most positive developments in this law is the introduction of a fast-track citizenship pathway for individuals in critical occupations. Eligible green card holders working in healthcare, technology, science, and education may qualify for U.S. citizenship after just 3 years of permanent residence. Continuous employment in an approved field is required, and USCIS will publish a detailed list of qualifying occupations. This pathway recognizes the contributions of essential professionals and offers a strategic opportunity to reduce long-term uncertainty. Planning employment documentation now can significantly improve eligibility when applications open. Family protection is another major focus of this reform. The law expands access to work authorization for family members while petitions are pending, reducing financial strain and preventing forced separation during long processing delays. It also strengthens age-out protections for children, ensuring they do not lose eligibility simply because government processing took too long. These changes directly address long-standing hardships faced by immigrant families. While paperwork is still required, the system now better reflects real family circumstances rather than rigid deadlines. Criminal records and immigration systems are now more tightly connected than ever. Law enforcement agencies automatically notify USCIS when green card holders are arrested or charged. While an arrest alone does not equal guilt or automatic immigration consequences, certain charges can trigger mandatory detention reviews or heightened scrutiny. This makes early legal advice critical. Even minor cases can have serious immigration consequences if handled incorrectly. Green card holders should never assume a criminal matter is local or unrelated to immigration. Consulting both a criminal defense attorney and an immigration attorney before making decisions is now essential. At the same time, the law introduces meaningful relief provisions. Green card holders now have access to 18-month provisional extensions if renewal processing is delayed. Emergency replacement options for lost or stolen green cards have been improved, and temporary proof of lawful permanent residence can be issued more quickly. Dedicated emergency processing channels now exist for urgent situations involving work, travel, or medical needs. These updates recognize that many delays are caused by system backlogs, not applicant mistakes. For conditional green card holders, the law provides long-needed clarity. Filing windows for removing conditions have been expanded, and USCIS has issued clearer guidance for cases involving divorce, separation, abuse, or the death of a spouse. Officers are directed to focus on intent and credibility rather than technical errors alone. This creates a more humane and predictable process for genuine families facing unexpected hardship. Action is now essential. Green card holders should track expiration dates, biometric timelines, and travel history carefully. Maintaining organized tax records, employment documentation, and proof of residence reduces future risk. Registering for a USCIS online account is one of the most important steps, as it ensures faster access to notices and deadlines. The goal is not perfection, but preparation. Staying organized protects your status and reduces stress. Some situations require professional guidance. Individuals with criminal history, extended international travel, public benefits usage, complex family circumstances, or pending citizenship applications should seek legal advice early. Legal consultation is not a sign of trouble, it is a strategic decision to protect your future. This law reflects a broader transformation of the U.S. immigration system. Enforcement is becoming digital, predictable, and data driven. Compliance is no longer just an obligation, it is protection. Green card holders who stay informed, responsive, and organized will benefit from stability and clarity. While the system is less flexible, it is more transparent for those who follow the rules. The most important takeaway is simple: preparation beats panic. Nothing in this law changes your right to live and work in the United States if you meet the requirements. Understanding the rules early puts you in control and reduces long term risk. Knowledge creates confidence, and with awareness and compliance, lawful permanent residents can move forward securely under the new system.